Hello, and welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan. I've been practicing law now for 24 years in the fields of consumer protection and lemon law. Frequent writer for Jalopnik's subblog, The Garage, and I write for Opposite Law from time to time as well. Today we're going to talk about things you can't sue for. These are things you cannot sue for. People call my office every day hoping to sue somebody, and usually it's a car company for selling a defective car. But sometimes people ask me about other things. They say, I'd like to sue somebody for this, I had something bad happen to me, or I've lost a lot of money, or I've been hurt somehow. Can I sue somebody for this? And people don't understand what it is that means you can sue somebody or why you can't sue somebody. So we'll talk about that. To have a successful lawsuit where you collect something from somebody usually requires two things: liability and damages. Damages are easy. That's what somebody owes you because they've hurt you. But liability is why they owe you the money. And you can often have liability arising from a statute or from common law. I'm going to have to summarize quite a bit of this for a podcast, but I think I can do it and get it to understandable levels. So to have this work out, you need to have two numbers that are not zero. If either number is zero, you get nothing. So you can have a situation with huge liability but no damages, you get nothing. You can have a case with zero liability, huge damages, still you get nothing. I'll give you an example. Guy contacts me, says, look, Steve, I went to a store, pulled in the parking lot, parked my car, took my kid up, put the kid on the ground, and the kid ran across the parking lot and burned his feet on the asphalt. Can I sue the parking lot owner? And I said, well, let me ask you a couple questions. Why was the parking lot hot? He said, well, it's a blacktop parking lot, bright sunlight. I said, okay. Why was your child not wearing shoes? And he said, well, my kid takes them off all the time, and I didn't put them back on, and I just thought, well, we're just going in the store for a few minutes. He doesn't need to have shoes on. And I said, okay, and then why was the kid running loose in the parking lot? He said, well, as a little kid, he does that. And I said, okay, now this is your little kid and you know your little kid does these things? And he said, yeah. I said, so who's at fault here really? Now, I didn't quite phrase it like this when I was talking to him, but we tapped the answer around and I think he got the message. When you ask yourself about that situation and who got hurt there and why they got hurt, the average person is going to look at that and go, well, it's the father's fault. That's not the parking lot's fault. It's not the landlord of the parking lot's fault. It's the father's fault. He's the one who should have known this was going to happen and should have taken steps to prevent it. So a lot of things that happen in our society are as a result of negligence, that somebody owes a duty to somebody else and they breach that duty. Most common duty you think about is driving a car. If you're driving a car, you have to drive the car safely. If you don't drive the car safely and you harm somebody in the process in a car accident and you run a red light, for instance, you might owe them money, and that would be as a result of automobile negligence, okay? So in a situation like the father who puts his kid down in the parking lot, you ask yourself, who owes who duties here? And a landlord might owe a duty to somebody who's coming on their property legally. So for instance, if there's a big hole in the parking lot that's not, roped off or something, and you get out and fall in the hole, yeah, there might be liability there. But do they owe a duty to warn all visitors that, by the way, the blacktop is hot in the summertime? And the answer to that is obviously no. The person who owed a duty here was the father who owed his child a duty to not let him run around barefoot in a parking lot. So there were damages there. The kid had to go to the hospital. Okay, there were damages there. The kid got hurt, and this is not funny in that respect. But there were damages, but no liability. At least not liability the father's going to sue for, because the kid might have had a great lawsuit against his dad, but that's not going to happen. So there were damages, but no liability. Now, you might ask yourself, Steve, what kind of liability might there be where there's no damages? And there are situations where people can, violate a statute, for instance, but there's no harm. Therefore, there's no violation. There might not be anything that you can do about it. Now, a lot of times people think that something crazy happened or something bad happened, and therefore they should get some money for it, okay? And I'll give you a couple examples. A lot of people call my office about defective cars. And they say, I've got this car and it stalls and I want it bought back under the lemon law. I say, great, I can get that done for you if it's documented well enough. People say, I also want some money for the time I was driving down the road and I almost got killed. And I say, well, unfortunately you can't collect for that. They say, why not? I said, because you weren't killed. You were almost killed. You almost have a case for wrongful death, but you don't, okay? Things that almost happen to you don't create liability. You must have actually had damages. And the fact that you almost got killed isn't damages. Another example, and this, I hate to keep using the car examples, but I know so many of them from what I do for a living. Let's suppose you buy a brand new car. You drive it off the lot, and the next day the engine explodes. And I've had that happen in 24 years of lemon law cases. I've actually had people who've had very, very catastrophic things go wrong with their cars on day one or day two. It's amazing how that can happen. But over the large number of cars I've handled, it happens. So you have this car, the engine explodes, and people say, well, the dealership, all they're going to do for me is replace the engine. I say, well, what does the warranty say? And then they read the warranty, and the warranty booklet in most cars says, if your car suffers from a defect or a malfunction, we have the right to fix it, and we can fix it using remanufactured parts if necessary. Now, no one ever catches that in their owner's manual until it's too late. And they say, wait, they can put a remanufactured engine in my car despite the fact my car's only got like 12 miles on it? And I say, yeah, that's what the warranty says. And people say, yes, but Steve, now my car's worth less money because it's had an engine replacement. Now, let's assume for a moment that that's true. Let's assume that that's possibly true, okay? That your car's worth less money because the engine's been replaced. So you have damages, but what's the liability, okay? There is no liability here because the warranty specifically says they're allowed to do this. So you've got damages, but no liability. You can't sue for that. And this is one of the most common things people ask me about. They say, Steve, my car's been devalued. I want to sue for that. I say, well, unfortunately, you can't sue just because it's been devalued. You have to have something you can point to and say, this is also a violation that creates liability for which I can sue somebody for, okay? Another common thing that people ask me about, they say, Steve, I got treated like dirt by somebody. I was trying to deal with Ford Motor Company or Chrysler or GM or GE or AT&T or Verizon or whoever. I was dealing with a big corporation and they treated me poorly. Can I sue for that? I say, no, because you got treated badly. Number one, what are your damages? And number two, what's the liability? Bad things happen to us in our society. This is one of the things that just happens as part of a life, okay? The fact that somebody did something bad to you does not mean that they owe you money, okay? Taking it one step further, I know people who say, well, I want to get compensated for all the times I brought my car to the dealership. I've had people who brought their car into the dealership for dozens and dozens of repair attempts, okay? And I've known people who, for instance, they bring their car in, every single time they bring it in, they're told, we don't have a loaner for you. So the person sits there for half a day, loses a day of work. It's a pain, and they say, okay, I want to get compensated for that. I say, what do you think the compensation is for? Okay, in other words, you have damages. No question you've been harmed, but what's the liability that created that harm? And they say, well, I don't know, is there liability under the lemon law? I say, no, the lemon law actually lists what you can get, and it does not list lost work. At least not in Michigan, it doesn't. So there's no liability despite the fact that you might have damages, okay? So again, the fact that your vehicle's devalued or that you've lost work or that you've been treated poorly, these aren't things you can get compensated for. Now, a lot of people will say, well, Steve, I hear about these crazy lawsuits all the time. First of all, anytime someone tells you about a crazy lawsuit, look it up on Snopes. 9 times out of 10, it's not true, okay? And the 1 time out of 10 that it might be true, it's usually been exaggerated so badly that the story being told in the news is not correct, okay? So I'll give you the example of the McDonald's coffee, okay? And if you don't know the story of the McDonald's coffee correctly, you should actually go look up, there's a documentary on this, okay, about the hot coffee case. Because what happened after the lawsuit took place, we'll talk about the lawsuit in a second, but after the lawsuit took place, a couple big corporations, in an attempt to get our system changed in America, lied about what happened in that case and said this woman got millions of dollars because she's driving along and spilled hot coffee on herself and was so stupid she didn't understand that coffee was hot. And she got millions of dollars, and that's what's wrong with America today. And it got to the point where, Seinfeld even did a whole episode about hot coffee. So people out there have all heard about this case. They say, yeah, there's this stupid woman who got this money because she spilled coffee on herself. But if you actually study the case, you'll discover that the coffee that spilled on her was hotter than the industry standard, and the industry standard was lower because it was safer. And McDonald's at the time purposely sold their coffee hotter, knowing it was dangerous, and at the trial, one of McDonald's own people got up on the stand and said, yes, that woman was burned, yes, she needed skin grafts, yes, what happened to her was horrible, but you know something? She's only one out of so many millions of people who buy coffee every day. She is statistically insignificant. And when the jury heard that McDonald's didn't care about the fact this woman had skin grafts as a result of the hot coffee, they awarded her a bunch of money, which, by the way, got reduced on appeal and was not millions of dollars, okay? So if you understand the facts of the case and you see the photographs of her injuries, and you understand that McDonald's then lowered the temperature of their coffee afterwards, you understand that it's not that crazy of a case, okay? So when you hear about crazy cases, number one, look them up on Snopes. They're not normally true. But number two, there's normally something else going on. And another example, of course, is the cigarette cases. People have sued cigarette companies, tobacco companies, saying that, I got lung cancer and I want to sue the cigarette company. And again, Seinfeld cracked a joke about this whole episode. And people say, well, wait, we've all known that cigarettes cause cancer. We've known this for decades. Like, who in their right mind would file a lawsuit? Well, you go look up one of the cases and you discover that most of the successful cases, and there have been some, have taken place where somebody started smoking back in the day when cigarette companies actually advertised and said specifically, not that the cigarettes don't cause cancer, our cigarettes are good for you. You can find ads where cigarette companies actually said, our cigarettes are good for you. They'd have doctors purportedly smoking in the ad and saying, I'm a doctor, these are the ones I smoke because these are good for you, okay? So back up now and ask yourself, if a big corporation puts a product on the market and says it is not only safe, but it's actually good for you, and you get harmed as a result, you'd understand then why there'd be some liability there. And lung cancer, of course, would be your damages, okay? So the idea about suing over the cigarettes is not that crazy if the facts are right. Most people would understand that if you were to start smoking today at the age of 18 and you got some dread disease and you filed a lawsuit a couple years down the road from now, most people would understand and say, well, that person probably doesn't really deserve a lot of money because when they started smoking, there were warnings on the packages yay big with photographs of cancer-encrusted lungs saying, smoking is bad for you, it will kill you. And if you went ahead and smoked despite seeing that warning, then you probably have assumed some sort of risk, okay? So again, these are things that you may or may not be able to sue for in the broader scheme of things, but you understand why there's exceptions to this. Another thing that a lot of people don't understand that they can't sue for is when they've signed a waiver or a disclaimer or an arbitration clause, okay? So if you sign an arbitration clause, oftentimes you can't sue the person who got you to sign the clause. I've talked about this many times on this show about how arbitration clauses will remove your ability to sue somebody. But likewise, waivers or releases also mean you can't sue somebody. So you go to a horseback riding ranch, and before you get on the back of the horse, they hand you a piece of paper, say, here, sign here, and you sign this thing saying, I'm an adult and I promise not to sue, and blah, 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 blah. And you jump on the horse, next thing you know, you're bolting across the property and the horse throws you off against a brick wall, and now you're quadriplegic and you'd like to sue somebody for that. And in many states, assuming you're an adult and you're of sound mind and you signed that waiver knowingly or that release knowingly, you're not going to be able to sue for that. Your lawsuit will get thrown out. And I've seen situations before where people have gotten injured in very, very strange ways. There's a very bizarre case out of Michigan where a beer company would run a promotion where they would say, we're going to have sumo wrestling at the bar tonight. Come on down, get some free beer, have some fun. And they have you put on these big inflatable suits where you look like the Michelin Man, and you and another person dressed similarly get in a ring and bounce off each other, and eventually somebody falls down and they lose. And it involves alcohol, so it doesn't normally take that long for someone to fall down. Well, as you might imagine, somebody fell down and got hurt despite wearing this big inflatable Michelin Man suit, and they wanted to sue because they said, no one warned me the dangers of sumo wrestling wearing this big inflatable suit. And of course, the trial court threw it out and said, you can't sue because you signed a waiver. And the waiver specifically said, I'm going to engage in this sumo wrestling wearing a big inflatable suit, and I understand I could get hurt, and I promise not to sue any of the people involved in this for what might happen to me. And a lot of people get upset because they say, well, you know something, I thought the waiver only addressed the typical stuff, but I didn't think it would address the wacky stuff, okay? And that's usually what happens is someone gets hurt in a freak accident despite having signed a waiver. And in many states, including Michigan, doesn't matter how freaky the accident is. The fact of the matter is that you got hurt doing the activity for which you signed the release. So when you sign that release, you are probably telling yourself and everyone else, I can't sue anybody for what might happen to me next. Now, of course, there's a big gray area if something really crazy happens that couldn't possibly be anticipated by anybody. So let's suppose we're going to go back to horseback riding situation, and you're riding on horseback and the owner of the ranch shoots you. Well, most people would say, well, gee, I didn't think I was signing a release so the guy could shoot me. But so I'm sure that he'd say, well, you can't sue me, you signed a release, but a court might not say the release covers that. But it's certainly going to cover anything that's possibly related to something that happened to you on the back of that horse or while you're on that property. I wouldn't be surprised if you signed the release about horseback riding that if you got off the horse and were walking back to your car, if the horse decided to run over and kick you one last time, that you probably can't sue them for that either. Because again, this release is going to cover them for any activity related to your participation that day in the activities of horseback riding. So again, when you sign the release or the waivers, these are things you cannot sue for. And I've seen contracts that contain these kinds of things. I've also seen contracts that contain the arbitration clauses. And arbitration clauses, of course, are subject to a lot of debate these days because the U.S. Supreme Court has said that an arbitration clause, for instance, can be upheld and specifically keep you from, for instance, filing a class action. And there are situations where without a class action, consumers cannot get any help whatsoever. So arbitration clauses also oftentimes act as a complete bar to your action, just the same way a waiver or a release does. So you got to be very careful signing these documents. But again, anytime something bad happens to you and you think you've been harmed and you think somebody might owe you money, you have to ask yourself, one is, did I suffer real harm? Did I actually get injured? Many states won't compensate you for harm that simply happened in your head. You were scared, but you got better, okay? You got frightened, but you're not in the hospital. If you don't suffer a physical manifestation of harm, a lot of times you can't recover damages or money for that, okay? So you have to ask yourself, was I really hurt? A lot of times we look at that and say, well, did you go to the hospital or did you suffer out-of-pocket damages? Did you have to pay some money for something to get fixed, for instance? So damages. But then you have to ask yourself, okay, and who does the liability run to? Who owes me this money? And ask yourself, who owes it to you and why do you think they owe it to you? Because that's important. And if it seems like somebody did something wrong, okay, then you might want to call an attorney and say, well, is this negligence? Okay, there's some things that may or may not be that obvious to you, that somebody did something wrong. But when you start realizing, well, wait a second, maybe I did something wrong here. Maybe I shouldn't have put my kid down barefoot in the parking lot and said, here, go run inside the store. You might have to rethink that. Again, always feel free to call an attorney and ask. Most attorneys will answer these questions for free and they won't charge you a cent to do so. So call and ask, but be ready for the idea that an attorney might say, something, you have suffered injury, but there is no negligence here or no liability here that goes against somebody else. And of course, we could talk for hours about how you can have liability and damages and sue somebody and not collect simply because someone's not collectible. But that's another story altogether. All we're talking about today is things you can't sue somebody for. And those are things you can't sue somebody for. So I hope that answers your questions. If not, send emails to me or contact me through my website, lehtoslaw.com, LEHTOSLAW.com. I'm on Twitter at Steve Lehto, at STEVELEHTO. And this show's on iTunes, Stitcher, SoundCloud, and YouTube. Thanks for listening and watching. Bye-bye.